Welcome back to Canadian Justice, where we're discussing a recent ruling from the Alberta Court of Appeal that the Impact Assessment Act, or the federal No More Pipelines Act, is unconstitutional. Now, we're discussing the law. Brett, in the last segment, I wanted to get into this idea of what the type of impacts that the law considers when the government's determining if a project will be approved or not. Because I think there's this sort of famous example of the government considering gender and how gender will be impacted by a mine or an oil development project. What is that all about, and what are some of the other impacts that are considered?
So I think it's helpful to separate two stages of this legislation, and there's different impacts considered at each stage. So when determining whether a project might be designated under the regulations and therefore subject to a hold, you're not allowed to do anything if you're designated, the federal government has listed out certain what's called effects within federal jurisdiction. And those effects can be the traditional sort of areas of fisheries or migratory birds or indigenous impacts. But the court really took issue with how broad this definition really was. So it allows the agency to consider things which arguably are not within federal jurisdiction, such as greenhouse gas emissions and things like that. So the area that you referenced is once the agency has determined that an impact assessment is required, it then has to apply what's called the Section 22 mandatory impacts or considerations. And the Act enumerates a list of these, one of which includes gender. Also, it includes, the need for the project, other alternatives, social, economic, health impacts and stuff like that. And essentially, it says that the agency must consider these things, and that eventually works its way into conditions that will be set and the public interest determination, and ultimately potentially the decision to go forward or not.
So a lot of different things that are considered. And this has resulted in a lot of critics saying that this is a no more pipelines law. That's kind of the nickname that it's received from a lot of people, including, I think, the Premier of Alberta. Now, as I said at the beginning, that sounds hyperbolic, but Sean, I want to know, how likely is it actually that a new pipeline could be built with this law in place?
Well, it will continue to be a project-by-project assessment. However, a lot of the concerns come out of the practical effects of the law. As you alluded to earlier, Christine, the fact of the matter is the Act imposes considerable uncertainty in terms of the timing, and it politicizes the assessment process as well to a considerable degree. So if you're a private sector proponent looking to invest in building a major infrastructure project that was already subject to considerable uncertainty with respect to timing in this country, this Act just exacerbates that. So it makes it increasingly unlikely that private investment capital may go into a new infrastructure project.
Dwight, so we've gone over what the law does, kind of how it works. Now let's talk about some of the objections. The Alberta government called this law a Trojan horse that brings the federal government into the provincial sphere. Can you explain that argument?
Well, so this is the element where the law ends up regulating projects that are entirely within a province and that are normally within the jurisdiction of the provinces to regulate. Matters related to natural resources are within provincial jurisdiction. There are a number of what are called heads of power, the powers of the provincial government, into which natural resource projects that are entirely within a province normally fall. And the federal government finds a way in a much larger way than previously into carrying out environmental assessments of those. And the Alberta government raised the issue, is that a Trojan horse for more? The Alberta Court of Appeal, in a 4-1 decision, says that in fact the federal government has gone too far with this law, that the law really does become about the regulation of projects that are within the province and is thus outside federal jurisdiction.
Dwight, we've only got about 30 seconds, but as I said, it comes down to the division of powers. So how did the federal government justify the law? How did they say it was within their power at the Court of Appeal?
Well, they really tried to argue that it's about cooperative federalism and that they've been able to carry out environmental assessments on the same project as the provinces. There's more to it, but at an unnuanced level, that was their claim, that it's about cooperative federalism and it's fine for both governments to regulate at the same time.
Well, I mean, the nuances of federalism are kind of hard to get into in the 30 seconds that I gave you, Dwight, but it's a good explanation. We've got to go to commercial break, but we will be right back.